All right, good morning, everyone. All right, there's two more people. Wow, what a crowd. Good morning. Okay.
I wanted to take this off consent.
Sure.
It's off consent.
It's already off.
Yes, ma'am. That's the first item, I think.
What number is it?
Education? Oh, yes, it's this one. Okay.
21600, whatever.
All right, we will take
Okay.
that one off.
Thank you.
All right. Let's see, we have some people missing. So Representative Grota can sit in for Representative Hatch, Representative Fellows for Senator Chandley, and Representative Hacken Phillips for Senator Whitley would be the way to do it. And on the minutes, I believe there's a correction.
Yes. On item 5 on the proposed minutes, staff overlooked the fact that this was final proposal 2022-229 from HHS about the immunization registry rules. Representative Leon had requested that the agency amend its religious exemption form by removing the phrase "request for a." That was to clarify that the religious exemption is a right and does not require a request. Senator Lang included that change in his conditional approval, and that was approved by the committee, and the department did make the change on its form.
Oh, excellent, thank you. Does someone have a motion on the minutes?
Move to approve as amended?
Second.
Any other additions, corrections, or comments? Right, seeing none. Those in
Move to
favor?
Move to approve.
Already moved.
Oh,
Yeah,
I'm
already-
doubly moving.
You seconded, Representative Schmidt. Those in favor?
Aye.
Any opposed? All right, thank you very much. And Senator Gray, welcome. You can sit in for Senator Ward, who I don't believe is here.
Thank you.
Okay, so we have a full slate, amazing.
Move
All
to
right.
approve consent?
Representative,
Oh, actually, let me rephrase. We want to pull something off, correct?
yes, you move to approve consent, and Representative Fellows has moved to take off item G. Okay. Is there a second to approve consent? Okay, Representative Leon, any discussion on consent or any other items to come off? All right, seeing none, those in favor?
Aye.
Opposed? All right. On to the regular agenda and Department of Education. And we will cover that item off consent at the same time, just to save you the trouble.
So for 2022 to 21, the comprehensive agricultural educators, the reason this is on the regular agenda is because the board is repealing the certification based on the recommendations from the Professional Standards Board. The recommendation was based on the low number of educators that currently work in this field and hold this certification. Upon looking upon the agency's website, there were only 2 people listed who had this certification. So it was placed on the agenda in case the committee had any questions about why that certification was being repealed and what will happen to those 2 individuals.
Representative Broda?
So I would imagine that this went through the regular public meetings, and so people are aware that we're doing that, as well as the 2 people are certified.
Yes, the agency is nodding very vigorously. Would you introduce yourself, please?
Julie Shea, Administrative Rules Coordinator for Department of Ed.
Steve Appleby, Division Director, Department of Education.
Thank you. I presume that the 2 certified people will continue to be employed because we haven't taken their skills away, just a piece of paper.
That is correct.
Okay. Any other questions, Representative Fellows?
I looked on the certification database, and I found that there were 7 people with that certification that are employed.
Thank you for the question. There are, however, many of the individuals hold other endorsements, and this endorsement is actually redundant to the Career and Tech Ed Agriculture endorsement. So all of these folks qualify at no cost to them for the CTE Agriculture endorsement.
Follow up.
Follow up, please.
So when I looked on the certification database, I found only 2 people certified with the general agricultural educator, and comprehensive agricultural educator is a different endorsement.
Yeah, so essentially we're combining these two endorsements because the requirements are identical with one exception, and that is the degree requirement. The degree requirement for the non-CTE, which is comprehensive agriculture, this rule set, that degree requirement is a bachelor's degree. The Career and Tech Ed endorsement does not have that bachelor's degree requirement, but the competencies and expectations are substantially the same.
So what you're
Follow up, yes.
So essentially, what you're doing is you're repealing the general agricultural endorsement.
We're repealing the comprehensive agriculture endorsement.
I think that there's some sort of confusion here because there are 7 people with that endorsement that are employed, and only one of those 7 has another endorsement that's related to agriculture, and that would be animal science or
Husbandry.
some kind of animal thing. So I think that there's a confusion here.
So the state board is repealing the comprehensive agriculture endorsement. Whether it's 2 people hold it or 7 really doesn't ultimately matter. Everyone who holds it has been notified via email, and we have been in contact with them, and they will automatically be eligible for the Career and Tech Ed Agriculture endorsement by nature of holding currently comp agriculture. So we're essentially, again, collapsing 2 separate endorsements with the same requirements into one.
So what are those 2 endorsements?
One is comprehensive agriculture educator or teacher, and the other one is the CTE agriculture. And then under that CTE agriculture, there are some sub endorsements like animal science, those types of things.
Okay, thank you. So this has been approved by the Board of Education. It's had the proper comment,
Yep.
and we're essentially transitioning agricultural teaching from the general education pool into the CTE pool. Is that correct?
That is correct.
Okay. Well, I'm not sure I agree with that. People ought to know about agriculture everywhere, but that's not my decision to make. Any other questions or comments, Representative Lynn?
Yeah, so I guess I want to make sure that I'm understanding. You said that the position that these people, the 2 people will be transitioned into does not require a bachelor's degree. Is that correct?
Correct. So we have 2 endorsements today, both agriculture.
Right.
One requires a bachelor's degree, which that person, there were only several of them statewide, and that teach in a non-CTE center under that endorsement. Those
Okay.
folks, this does not affect their ability to do the job, as the chair
Right.
pointed out. This is just
Right.
what license they hold. And so those folks can then, they qualify automatically for the CTE agriculture endorsement if they want to maintain licensure. And that would allow them to continue.
Right. I guess the only thing I'm concerned about is the effect of this, that we're sort of lowering the standards that are required for people that teach in this area. In other words, now, at least for some of what of the people that previously were required to have bachelor's degrees, now they don't. And I'm just wondering if that, in effect, is a lowering of the standards.
I won't speak for the state board, but that wasn't their feeling. We have a situation right now in one of our districts where a CTE center is across the parking lot from a high school. And they teach the same agriculture class across the parking lot from each other, but one has a higher requirement for licensure than the other, but it's the same class. So the state board felt that that didn't make a lot of sense.
I presume that all teachers, regardless of their certification, do have a bachelor's degree in something.
Not in our CTE centers.
Ah. They may have hands-on experience instead. Representative Broda?
So I'm going to echo Representative Lynn's concern in that because there are two high schools with similar programs, that high school is not going to issue a bachelor's, right? It's just going to issue a high school diploma. So you're talking about two similar tracks. So I can understand how the CTE program comes into play, but I don't understand repealing a bachelor's program.
It's not a bachelor's program.
Did you say a
No,
BA?
The teacher must have a bachelor's, presumably in agriculture.
I'm sorry. When you said BA, it confused me. Okay, thank you. I apologize.
So would it be fair to assume that the high schools that currently have agricultural programs may eliminate them in favor of sending people to the CTE? Or are they able to continue teaching them with teachers without a specific agricultural certification?
Yes. In fact, this should actually allow more high schools to add agriculture programs because the requirements for agriculture teacher were much higher than the CTE requirements, right? So that held back some high schools, it's our understanding, from offering agricultural programs because they couldn't get a licensed teacher in this area.
Thank you. All right. Representative
Oh, I'm sorry. but I
Fellows
do-
and then Lynn.
So can you look up the two endorsements that you're talking about? Because I just think that it's not clear which one you're eliminating. I mean, I don't know by looking at 507.04 and I don't know, what is the other one?
Thank you, Madam Chair. So again, on the packet that was given us on 22.221, right under 6A, it says the Board of Education is proposing the repeal of Ed 507.04 on the certification of comprehensive agriculture educator. So I think it's clear what they're eliminating. I think the idea that, if I understand the agency correct, is that all they're doing is folding this comprehensive certification into the CTE certification so that either in high school or a CTE center, a teacher that holds a CTE certification can teach in both environments.
Okay. Representative Lynn?
So I guess I'm still not clear on this aspect of it. In other words, why? And please understand, I certainly don't suggest that that there shouldn't be some grandfather provision for people who are currently teaching and don't have a degree. But I guess I'm not, I mean, why is it that you've decided that the way to handle this is to eliminate the bachelor's requirement for these two teachers, as opposed to saying, we're going to require a bachelor's degree for everybody that teaches in this area, and we will grandfather the people that don't have it for now, but going forward, I mean, it does sort of seem that you really are lowering the standards. You're saying that the bachelor's degree is not important for this teaching.
So just for a little background on the process of how these rules land here. The first thing that occurs is the Professional Standards Board forms a committee, typically several years prior to expiration of any rule. And the Professional Standards Board is made up of educators from our public system, superintendents, teachers, other practitioners. And their subcommittee conducted a study. They looked at what other states do. They surveyed folks from the field. And then they combined all that into a recommendation to the state board. And their recommendation was the repeal of this endorsement and just going with the CTE endorsement. The state board then held their normal course of meetings, had public hearing. I don't believe we received any comment regarding the repeal at the state board. And at that point, the state board unanimously passed, as the PSB had done, repealing this and just using the CTE endorsement moving forward. So, and to clarify the numbers, the CTE general agriculture endorsement, there are 2 individuals. The comprehensive agriculture, there are 7 individuals. Those 7 will get the CTE agriculture endorsement moving forward. They will not need to have it to teach in a non-CTE high school because this will become a non-credentialed role in those high schools. The local superintendent can still require the individual to hold a bachelor's degree in order to hire them. It just means that to get the CTE agriculture endorsement, they will no longer have that degree requirement. But there is quite a process to this over several years, and a lot of it comes from the field itself. So we did hear superintendents that feel that there is a barrier to them offering agriculture classes because many folks from that field, similar to whether it's an auto mechanic or a welder, don't tend to have bachelor's degrees.
Thank you.
Thank you. Senator Lang.
So again, I just, well, we're just approving the rule here, just as a statement and comment, is that many businesses, including the state of New Hampshire, state of Maryland, are removing bachelor degrees from job-specific positions, things like IT and things like agriculture, things where degrees were required, they're now substituting experience on a regular basis in the workforce that we're in. And so I don't think this is an uncommon move in industry right now, both in teachers, why we have CTE programs. Again, CTE programs use people who are experts in their field, but may not necessarily have a degree. And they're just as capable of teaching the expert topic that they're talking about. So I don't see a problem with doing this. I think it's a good move for us, especially in the labor market that we're in.
All right. Other questions?
I just
Yes, Representative
Just
Fellows.
one more comment, that explanation makes sense. But
Thank
when
you.
I hear that there are only 2 people in the program from your testimony, I know that the certification that has 2 employees is called general agriculture and not comprehensive agriculture, which has 7 people certified. And when I looked up people working in a school district with an either general agricultural, comprehensive agricultural, animal science, or horticulture, I came up with 23 people. And this is impacting 7 of 23, which is significant. And I just, the fact that you tell me that there's only 2 people in this program is just concerning.
Can I just clarify for the record that the number 2 first came from OLS, not from my testimony?
Thank you. We appreciate your saying that you know how many people are in which category of certification.
Madam Chair,
Any-
move to approve.
Is there a second?
Second.
Okay, thank you. Seconded by Senator Ennis. And any further discussion? Those in favor?
Aye.
Opposed? Okay, thank you. Let's go on to the, what is it? The comprehensive business educator, which was taken off consent. Are there any comments on that?
No, I had no comments on this. It was consent. They are essentially repealing a section and then readopting it with amendments. So you'll see a bunch at the top, text that's been crossed out and then rewritten below it. But
So what's the essence of the change?
It looks like they're renumbering. See, currently outlined. The readopted, okay, the relevant requirements have been absorbed as amendments in the newly amended 507-49, making 507-48 no longer necessary.
Okay, thank you. That seems pretty clear. Any questions from the committee? Representative Fellows.
I'd like if you could give us a better explanation of this. So I looked at people
Excuse me,
employed.
Representative Fellows, if, since you've asked them for an explanation, perhaps they could take it from there.
Okay, we'll start with that.
Okay?
Thank you for the question, Representative. So we had a marketing endorsement and a business endorsement. And what the state board is doing is combining them into one endorsement. So taking the competencies of marketing, which was held by very few folks, and folding those into the requirements for business, and moving forward with one endorsement instead of two separate ones.
So the essence is that all people teaching business will need to know, have some competencies in marketing?
So the comprehensive business educator already had some elements of marketing in it. And what the PSB did is they took the comprehensive marketing educator, took some of those other pieces that weren't included in the business educator originally, and then they moved those under the business educator so that the marketing piece was a little bit more robust. And now all of those folks that hold the comprehensive business have a little bit more of a marketing requirement just because they have all of those different elements involved versus just the very specific marketing educator.
Thank you, that makes sense to me. Representative Ennis?
Just speaking as a marketing professor at UNH, I'm pretty comfortable with this change. Thank you.
And I would have to say that with my experience with small businesses in particular, having everybody learn something about marketing is very important. Representative Fellows?
One of the reasons I thought it made sense to have a separate marketing is that that's a very well subscribed major for college students. So I wonder if this has any impact on the dual enrollment program, or I don't know if you still call it, what is it like? There's another
Running Start?
another program that used to have where they could get credit for
The
both.
Running Start program. Yeah. I am not aware of any impact, but I'm also not, I can't answer either way to that question.
Okay, questions?
Move to approve?
Second.
Okay. Any further discussion? All right, seeing none, those in favor?
Aye.
Opposed? All right. Professional education requirements.
Madam Chairman,
Yes,
was the second on that Representative Schmidt?
yes,
Thank you.
okay.
For item 2023-10, this is on the professional education requirements for each graduate of a professional educator preparation program. The reason this is on the regular agenda is because these rules had expired on December 17th of 2021. So these rules are now currently being adopted.
For shame. You let the, what you have to say about that, please.
So this rule set points to a corresponding set of rules in the ED 500s. So there, many of our ED 600 rules, we're going to be back before you month after month in the future, because we're going to, instead of having all this voluminous text in the ED 600s that is identical to the ED 500s, we're merely going to change wording to point to the corresponding 500. So the 500s were in place, never expired, and those are a requirement of licensure. So having this expire had no net effect on our licensure operation because the 500s were still in effect. It's not a good reason why it expired. I'm just saying that's the net
Correct.
effect of it.
Any other questions or comments?
Move to approve?
Any further discussion? Those in favor?
Aye.
Those opposed? All right. Okay, thank you very much, and I think that's
Thank you.
right. Acquired brain disorder services in the community. Okay.
Staff has no comments on 2022-230. It was
In
pulled
that
up.
case, we'd like to hear from Stephanie Patnick. Good morning.
Good morning. Thank you so much for hearing my comments. My name is Stephanie Patrick. I'm from Disability Rights Center, and I wanted to talk to you about the HEM 310s. We did send a letter to the committee earlier this week expressing our concerns. So hopefully you received that. It is much more eloquently describes these issues than I will today, I'm sure. But hopefully you have that. I did bring some copies, so if you didn't see it, let me know. I'm happy to pass some of those around. I'm not sure if I have enough for everyone.
Yeah, I did not actually receive that. So I would like a copy.
Oh, you didn't? Okay.
No.
Yeah, we didn't, I didn't get it either.
Send it on Wednesday by email. I'm sorry.
Our office has been having internet problems lately, so I'm sorry.
All right. So rather than reading your letter, if you could summarize the important comments and concerns.
I would be happy to do that. So, Disability Rights Center, the goal of our agency is to protect the rights of people with disabilities across New Hampshire. And we have been having conversations with the Department of Health and Human Services over the past, I would say, year almost about this rule. And so we've made some progress, but we do have significant concerns still with the proposed rule and whether it complies with federal law.
Whether it what?
Whether it complies with federal law. So the federal law in the Center for Medicare and Medicaid Services makes it clear, and this is all about tenant protections for people who live in group homes. Let's give you the context of this. It says the HEM 310s protect the rights of people with developmental disabilities. And they provide an overview of the rights. The major proposed change that we are concerned about are the rights of tenants. So back in 2014, the federal government passed a law and rules called the HCBS Settings Rule. And what it says is that if people who live in group homes don't have the same rights as tenants who live in apartments in New Hampshire, the state is required to provide comparable rights. So it says, for settings in which landlord-tenant laws do not apply, which we believe they don't apply in these settings based on New Hampshire's law, because there are exceptions for people in group homes, the state must ensure that a lease, residency agreement, or other form of written agreement will be in place for each HCBS participant, and that the document provides protections that address eviction processes and appeals comparable to those provided under the jurisdiction's landlord-tenant laws. And so the letter just explains what our concerns are. The first one is that you have to have a notice whenever you're given a notice to be evicted, that you're going to be evicted, and it has to be very clear that it is not an order to vacate. That if you appeal the evictions procedure, you all know this, I'm sure, much better than I do in terms of evictions. If you appeal that eviction, you are allowed to stay in that place while the eviction is going through the process. And so the notice needs to be very clear on that. The second is that the rules around that are proposed around actually appealing that eviction do not make it clear that the person is allowed to stay during that process. And we feel like this is critical because it's also not clear otherwise how someone would be able to dispute whether they meet the criteria, specifically if the landlord alleges that their behavior would adversely affect the health or safety of other tenants, or that the tenant has caused substantial damage to the premises. And I will say that in our work representing people with disabilities, we often hear disputes about that. A provider who perhaps says that one threatening statement from a person with a disability, which is related to their disability, these are behaviors that they're working on, would cause that level of threat. And so we feel like it's critical that a person with a disability would actually be able to stay during the eviction process and be able to go in front of a judge and say, I don't believe that my behavior met this standard for evictions within the 72-hour notice. It's critical that the person is able to engage in the discovery process, to be able to provide their evidence that they are addressing these behaviors and that they are that they have an impartial person who can hear that, because otherwise it's just up to, I guess, the provider, the area agency. It's not exactly clear within the rule. So like I said, I sent you a very much more eloquent letter that explained those concerns. Hopefully you have none now, but we do not believe that the proposed rule provides sufficient protections for people with disabilities who have been alleged to be engaged in these behaviors and are appealing that decision by the provider.
Okay, thank you. That appears to demonstrate your concerns. Does the agency have a position?
Am I good?
Okay.
Stay
Yeah,
here or go?
First, do we have any questions? No, I think you made your point very clearly, and we'd like to hear from the agency on why they, what they're doing about it.
Thank you.
Good morning. My name is Melissa Nemeth. I am the attorney for the Bureau of Developmental Services.
Good morning, Allison Radmay, Administrator for the Administrative Rules Unit for the Department of Health and Human Services.
So, as Stephanie pointed out, this is the residency agreement is newly something that we're adding to the rule in order to comply with federal regulations. And it does say that individuals need to have rights comparable to individuals, what they would have under the landlord-tenant law. The department's position is that what we have in the rule and the residency agreement that is attached meets the requirements of giving notice. I'm looking at on the final proposal, it's page 20. Letter C provides information about if the provider is choosing to end the residency agreement. In number 1, the standard, if there's not a behavior that is alleged to be an immediate safety concern, is that the notification will be provided 90 days before the proposed termination date. And I highlight the word proposed, as I think that gets to the question about that is you're not moving out on that day. That's what we're proposing to end, sort of like in an eviction when you get a notice. We're proposing to end your tenancy on X date. So we have that provided in number 1.
Okay. Does that make sense to the committee, that Representative Hawken Phillips?
Yes, thank you, Madam Chair. So as an attorney who used to practice landlord-tenant law in the state of New Hampshire, I can assure the department as well as the committee here that there are notice requirements in eviction proceedings, the actual service that requires that special notification that this, there's verbatim verbiage that you have to include on the original notices that talk about this is not your day of leaving, this is your ability to appeal the process and to apply with the court to defeat this eviction. So, I mean, there are specific protections under RSA 540 and throughout that long landlord-tenant chapter that assures that verbiage is already included on any eviction notice. So I think that the concern is important on behalf of the woman who gave testimony earlier, but I think that our RSAs already do have those protections built in.
Except that RSA does not necessarily apply to someone living in a group home.
No, I don't think that is correct. I think the RSA for any evictions do fall under RSA 540.
That's
Our understanding is that the landlord-tenant law exempts these in RSA 540. It says facilities that are licensed under RSA 151 or certified under RSA 126A, and those are the types of locations that we're talking about. So that's why we're building that into the rule. But getting back to in the rule here in number 6 is language about if the resident fails to vacate the residence by the termination date, then the provider gives that notice and that would give them the ability to appeal. So they get the original notice, it would be 90 days in the ordinary course, or if there were significant concerns about someone's behavior causing safety concerns to themselves or others, it would be a 72-hour notice. But in either case, if the individual does not vacate the premises by that proposed termination date, then they get a notice to vacate within 3 days, and then that's what they are able to appeal. And because the landlord tenant laws don't apply, and these are overseen by the department, it would be to the department's administrative appeals unit that these hearings, where that would fall. So we feel like the information included here and the requirements for the notice are sufficient to meet the needs and give appropriate notice to folks. And they would, to the concern about, there was something raised about the discovery process and information they would be allowed to provide. There is another set of rules, HEC 200, that govern the administrative appeals process. And in that process, it addresses the exchange of discovery materials. So the department didn't feel it was needed to include that here in this rule, because this is just your rights. And if it falls into that appeal process, then those rules would be invoked and that process would be followed.
Follow up, Representative
Yeah,
Phillips?
just a quick follow-up. Could you cite the RSA for the group home tenancy that you mentioned before?
So that where I was looking was RSA 540:1 and definitions of actions against tenants.
Sure.
And it gives the exemptions under Roman numeral 4.
Yep.
And it's letter C.
Great.
There.
Thank you.
You're welcome.
Representative Groda?
So I think the woman who spoke before you, her concern was that these conditions would not or might not be properly identified to those individuals living in these facilities. So how do what you shared with us, prove otherwise or demonstrate otherwise?
So they would be able to appeal it if they got a 72-hour notice to leave, and we gave the expedited time frame, which is it tracks to landlord tenant law. If someone's behavior is dangerous, then but again, if they don't move out, then they get the right to appeal, and that's when they could raise through that appeals process is where they could challenge that they didn't feel that reason for them being provided that notice was appropriate.
Would it be reasonable to ask you to include the explicit language for that on any written notice that they receive? Because I can imagine that someone who receives such a notice might not be interested in wading through layers of laws and rules to find their rights.
So they're going to have attached to the rule is the residency agreement that they sign when they move in here, and there is a section in there that includes all of these provisions that I've talked about in the rule. They're incorporated in this form as well.
Okay, but what I'm specifically asking, if you're handing somebody a notice that you have to find a new place to live in 90 days, you should explicitly give them what they can do about it if they don't agree with the decision.
Especially the appeal aspect, I think. Otherwise, I agree with the chair entirely. It may be explicitly stated earlier in that document, but I think if you're going to be giving them that notice, you have to inform them as well that they have the right to appeal right there, so they don't have to dig around through their contract to find it.
Exactly, because I was particularly somebody who's been there for a while, probably can't find their contract. Senator Lang.
So the interesting one, again, on what page we're on? Page 20 of the rule, under number 6, it specifically says, besides, first they give them 90 days notice, and then it looks like if they don't move out, they give that 72-hour notice, and included on that notice, that 72-hour notice that they must leave, it says it includes the rights of the residents to an appeal and the notice in accordance with the appeal process that's listed below, and then the appeal process has all the other conditions. So I think we're giving notice across the board. Even at the last minute when the person still hasn't moved out, we're saying, oh, by the way, you have to get out, and here's your appeal process if you disagree with us. And they're telling them that in the notice requirement, at least according to the rule.
Yes. Representative Broda.
So my concern is that these are individuals that have special needs. They're there for a special reason, and they get this eviction notice, right? What if, if I would imagine that I would be very uncomfortable with that. And then, do I stick it under my bed? Do I, hide it? Do I pretend it didn't happen? What recourse? It says that you can call and it says you can have a a right to a team meeting, and maybe that is the protocol, but I just feel as if 3 days, with a 90-day, with a 3-day eviction notice, then to get the appeal notice seems to me a little bit too late. So I think that we should outline those things off at the very beginning so that these individuals who are challenged in ways that we do not know are given that help.
Yes, and since you already have that information of what the appeals process is, just make sure, reference it in C1, provide the notice in writing, and make sure that said notice includes the appeal process and the rights of the tenant.
So, Madam Chair, are we
Yes,
talking
Reverend
in number one on the 90-day notice, just including the appeal process in that 90-day notice? I mean, understand the 90-day notice is the resident, the legal guardian, and the service coordinator. So there are people just other than the resident getting this notice. There, his case handler and everybody else is getting that notice to be able to act on the resident's behalf. So I guess, it doesn't seem unreasonable to say, if we take that last line in number 6 that says, and include the rights of the resident to appeal, and add that to the 90-day notice so that they know in advance there's an appeal process. And they're not waiting to just 3 days before to find out there's an appeal process. Does that sound like a reasonable compromise?
Yes.
Okay, Representative
And
Leon?
if I could follow up, I think also, would that also be required? Would you be looking for that in number 4 as well? Number 4 is where a 72-hour notice is given if their behavior
Yes,
is dangerous. So
please.
you're saying in both of those places. I just wanted to be
Please, thank
clear.
you. That's a good idea. Representative Leon?
Thank you, Madam Chair. My question is a little more process related. It sounds like there's going to be significant changes to this. Are we going to have a chance to review that again before our final approval? Because I would like to be able to compare what's happened with the general community and in those that are under the Bureau of Developmental Services.
Actually, unless there are some other issues, this one, we've got some fairly specific language we want to include in 2 known places. So that would be a conditional approval if we were to approve. And that'll come back to us. Actually, it won't come back to us.
I guess my question is, I would like to be able to go a little deeper just to make sure there's nothing else we're missing that's provided to your average person that's not provided here. I'm just not sure what that would do to our process.
That's my question. Let's see what timeline looks like.
Which timeline? For us,
Right.
our deadline is May 23rd. When's the next meeting?
It would be before that.
Okay. All right, we will, are there any other questions or concerns, specific? All right, thank you. Excuse me, Ms. Patrick.
Just so that I can try to make sure that all of our concerns are covered.
Okay. All right, so we will ask you to include those items in a, for prior to conditional approval, and we will take it up at our next meeting to give the committee a chance to finish reading this rule.
So are you postponing this to the next meeting?
Yes,
Okay.
the decision.
Need a motion of that? Can we just do it?
Do we need a motion?
To postpone?
It would be
Yeah, okay.
helpful, yes.
So
Move-
those,
I move to postpone,
I'll second.
22,
Okay,
2:30. next
seconded
meeting.
by Leon and Hacken Phillips. Those in favor?
Aye.
Aye.
Opposed? All right, we will see this one again. All right, case management agencies. Who has that one, 241?
Yes, this is the case management agencies, and I also did not have any comments on this.
Okay. Are there any questions? I have a couple.
Good.
Last year, we found out there are multiple definitions of case manager. And does this conflict with any of them, or does it specify exactly what type of case manager is covered? Attorney Minoz?
So this is the licensing requirements for all case management agencies. Like in areas of sanitation, organization, administration, physical environment, health and safety, nursing services, resident environment, dietary needs, medical records. I had no comments.
All right.
I have a question.
Yes.
So essentially what this licensing requirement does is combines all the definitions of, this is how I interpreted it, that it combines all the definitions of case management agencies under one. Is that right? Or no?
I don't believe so.
No, it's an amendment. It's a readoption and with amendment.
Oh, I see. Okay.
Yeah.
Okay.
We last year when we were talking about it, there are multiple types of case management. Which type does this cover? General all-purpose case management, independent of providers?
It's the licensing of the agency, the case management agency.
All right.
So like the whole business, correct? Yeah.
All right. And is this, hello again.
Hello, good morning. Allison Radmay, Administrator for the Administrative Rules Unit for the Department of Health and Human Services. That's a mouthful.
Good morning. I'm Kelly Keefe, licensing for Health Facility Administration.
And I'm curious why you consider a case management agency to be a facility.
It's in RSA 151. It's described as an entity. It's actually under the home health agencies, and that is required to be licensed through 151.
Okay, but not, okay, go on.
It's a requirement for the department to license these case management agencies just as we would any other.
Yes,
Facility.
but something like sanitation and physical environment. I mean, if you're talking about a case management agency, it doesn't actually have residents, I would imagine. Is that correct? It seems like you're conflating it with something much bigger than what I assume a case management agency is.
I guess I'm unclear, or it's unclear. Are you looking at the notice?
Yes, yes.
Maybe you could start by telling us, can you define what a case management agency is? That might be helpful because
Yes.
what is that? What does that mean, case management agency?
Good morning. For the record, my name is Doreen Shockley. I am the manager of the Bureau of Licensing and Certification at the Department of Health and Human Services. Earlier this year or last year, it's hard to keep track, RSA 151 was changed to include case management agencies as part. I don't have that legislation in front of me. The definition in the rule for case management agencies is, hold please.
It's on page 2, letter I.
A case management agency means an organization in consultation with the client in the client's place of residence, arranges for and coordinates the delivery of care and services to meet the physical, emotional, medical, nursing, financial, legal, and social services needs of the client. The rule further describes and defines case manager, case management supervision, and all of those requirements for those that are being licensed. To your comment, Chairwoman McGuire, there are many definitions within the state of New Hampshire regarding case managers. There are many for personal care assistants. There are, I mean, there are many definitions, period, in the state of New Hampshire that are inconsistent in rules and in law. I think it is the department's overall goal to work collaboratively across the agency to make sure that there is consistency. We worked very closely with the community of providers that are licensed, incorporated and their input. So we believe that this is consistent with what the standard definition is. There could still be inconsistencies with some rules that we're unaware of, but to our knowledge, we've incorporated all of those.
Okay. Is this consistent with your corrective action plan to separate case management from service providers?
So that's not a question I can answer, but I have colleagues here. That doesn't fall under our bureau. That falls under a different bureau. Melissa Nemeth can speak to that.
Good morning again. Again, my name is Melissa Nemeth with the attorney for the Bureau of Developmental Services. And we do not see any conflict between this rule and the corrective action plan.
Thank you. Seems decisive. Representative Leon?
Thank you, Madam Chair. And actually, I have another question that you may be the right answer for, Melissa.
we need another
My
chair.
question is, there are concerns that this may be a violation of the conflict of interest. So I was curious about the status of the department waiver to continue our the waiver of conflict-free case management.
So the department is under a corrective action plan with CMS to ensure that there is conflict-free case management, and our deadline for compliance with that is July 1st of this year. And we believe that we're on track. This rule actually is, I think, doesn't really impact that process because there are a variety of other rules and some preview of coming attractions. You'll see several of them coming that work on all of the corrective action plan that the department is under. But this rule specifically doesn't really touch on that. The choice and the assurance that people get their free choice of a provider is covered in those other rules versus this rule.
So would I be correct to understand that sorry, as a follow-up, would I be correct to understand that the department did not seek a waiver to extend that deadline, as I was under the impression that the department was going to do that?
My understanding is that there is no waiver being sought for the deadline of July 1st to comply with conflict-free case management. There are a variety of other initiatives that are going on that fall outside of the corrective action plan, but it is not my knowledge that the department is seeking to waive that July 1st deadline.
Okay, thanks. That's news
Good
to
to
me.
know. Any other questions? Concerns? All right. Thank you very much. Emily Johnson?
Thank you, Madam Chair, members of the committee.
You have to speak into the microphone.
Thank you, Madam Chair, members of the committee. I'm Emily Johnson with Granite Case Management. Thanks for hearing my testimony this morning. It's Carolyn Virtue from Granite Case Management was able to work together with the department and had the opportunity to submit her comments to them, and I think we were generally happy with 819. However, the issues that were raised earlier by this committee regarding concerns of conflict of interest and the current corrective action plan that New Hampshire is under, we believe that the scope 81902, and I did hand out I have some testimony and some attachments, which I think were emailed to you earlier this morning. So I just will highlight briefly here what our concerns are in 819. In 81902C, we have a concern regarding that language that all licensed healthcare entities, whether residential or non-residential, where case management is a component of the services provided, to include but not limited to hospitals, nursing homes, home health agencies, assisted living facilities, resident rehabilitation, residential psychiatric treatment, substance use disorder residential facilities, non-emergency walk-in care centers, ambulatory surgical centers, end-stage renal dialysis centers, community residences, adult daycare centers.
Excuse me.
Yeah.
You're citing HEP 81901C. The version that we have, HEP 819.01, has no subsections. So that doesn't appear to be in the final version.
I thought she said
802, yes. 81902.
Oh, so it's a typo in your written testimony, which refers to 81901.
1902.
Oh, yes, and I apologize for that.
On the first page.
On
okay,
the first
that's a
page,
two.
under the issues, correct, and I
Thank you.
apologize.
No wonder I couldn't find it.
I know, and I'm sorry, I read that entire thing for you. So, anyway, so our issue with that is just that under state and federal regulations, case management is provided in these settings as part of the continuum of care.
But
So,
those entities are not case managers.
well, correct. That would be the idea. And case management, we do case management under CFI, right? We work with the Choices for Independence waiver, and we provide case management in these, in all of these facilities. So, and I did cite some law here for you regarding targeted case management that, excuse me, requires case management to be accessible to all individuals who require or are at risk of requiring nursing facility level of care.
What's that? Yes, I see.
I'm reading all over the place. I'm sorry. So this would include patients in these facilities that are listed in 81902C.
Okay, so those entities by that rule are exempted from the from this rule.
Yeah, from licensure requirement.
Okay. Questions? Representative Schmidt, you have a question?
They're indicating that they just.
All right, yes, thank you. In that case, we'll go on to, is that your major concern?
No.
Major concern.
So the major concern would be 81902E and 81902F, which we believe allow for a conflict of interest in case management, and that it goes against what CMS requires, federal regulations and state statutes regarding case management and the requirement that case management be delivered separate from other services. So if you're allowing for area agencies as listed here under E, or all entities providing service coordination to individuals receiving developmental disability services or acquired brain disorder services, and you're exempting them from this rule, then you're allowing those entities and area agencies to provide case management in coordination with other services, which is exactly what New Hampshire is dealing with right now under the corrective action plan with CMS. So I have attached to this testimony a copy of the corrective action plan template, and I apologize. I believe I only had 2 copies of that, and the rest of the committee members should be in your email. There was a lot of paper to print out this morning, so I did attach that, and that's the issue that we're dealing with right now under different waivers. So I fear that if you're going to put this into law, we'd be creating an issue. Because it's inconsistent with the federal regulations. So I would say through all of this, those are our major concerns.
Okay, so your major concern is the scope of the rule
Scope
rather
of the rule.
than any of the details further down?
Correct.
Okay, thank you. That helps a little.
Madam Chairman,
Dr. Senator Lang?
So again, I think your problem is the case management services and the direct services need to be separate, is what you're saying in this rule, right? And they're not,
Yes.
according to this, they could be combined into the same agency, and that's problematic.
Exactly.
Thank you.
Okay. All right, thank you. Mr.
Madam-
Clegg?
Madam Chair, thank you. Robert Clegg for the record. I just wanted to point out, somebody made mention of the law last year. It was Senate Bill 333, and it added, including a case management service provider to a home health care provider. And that's, I believe, what the department was referencing before. I just want to make sure everybody knew which one it was.
Okay. All right.
Did that bill
Representative
become
Smith?
law?
Yes, and it was
Thank
a bipartisan bill.
I recall the testimony and the issue very well. I just want to make sure it became law. Okay, thank you.
Representative Leon?
Thank you, Madam Chair. My question here is, I'm not sure if you're the right people to answer it, but my question is, are these case managers being carved out separate from all of these other entities that are licensed, just so that there's a license on the case managers who would not otherwise come underneath the scope of OPLC?
That's a good question. It looks more to me as though they are exempting case managers in area agents. There's already an existing scope, and they're taking people out of the scope.
We would agree with that. What they're doing is they're allowing people to be unlicensed and do the case management work, is the way we read the rule
Yes.
that they're trying to implement.
And I'd like to ask the agency why they think it is not a conflict of interest for entities, area agencies where case management is a component of the services provided. That seems to me to be clearly a conflict of interest. And the same with that in D&E. And if you could you explain that to me, please? I'm not a lawyer, but
Would you like us to? Thank you.
Good morning again. So in the scope, letter E, letter E, what used to be letter F, it looks like area agencies were always exempt from the licensure if they were providing case management. And we've added the entities providing service coordination. And the reason we don't think that this creates a problem with the conflict is there is a separate set of rules that govern the qualifications of service coordinators. And we think that it's important that it not be captured here. It's not that there should not be oversight or any assurances that they are following all of the federal regulations. It's just that this particular rule did not seem to be the vehicle to have that included. It cannot be the same agency that provides case management as provides the direct service. There is a very limited exception to that has been approved by CMS, that there's already a process for that. And in the rules that are going to be, as I said before, there are rules coming before you. We already have rules around service coordinators for developmental services. Service coordination is the term that is used for the person that literally coordinates all of the services for individuals. And because it is a nuanced set of services that are delivered, and there are requirements in addition to what might be under 819 for what they need to do, the department feels it's important to keep them in their own rules, but have the appropriate oversight, so that, as I said, the department does not see this as any indication that we are not following the corrective action plan. It's just that those particular folks providing service coordination to this population are better suited to fall under another rule and have their oversight provided there.
I take it those are the HEM 403 and 505 rules?
503 and 505, yes.
Well, then there's a typo in your.
Oh,
rule.
403, I'm sorry. That letter D doesn't apply. That's for community mental health centers. So we're not talking about that here. HEM 505 is for area agencies. HEM 503 is kind of the general rule for folks entering the developmental services system. And HEM 522 is the rules for folks getting services for an acquired brain disorder.
Okay, and Representative.
So
Levin?
can I just make sure that I'm understanding what you're saying? So you're saying that all the various agencies or service providers that would be exempted from 819.02 are covered by other provisions of law or regulations, and those other provisions of law or regulations also contain whatever conflict of interest provisions they need to contain, so that you're not in violation of federal law. Is that correct?
That's exactly
Okay.
correct.
All right. Thank you.
Okay, well, I think these rules could be worded a little more clearly, because as I read D and E, it sounds as though the mental health program or the area agency is providing case management and other services, which you say is which seems like a conflict of interest to me.
Under, so I can't, the community mental health centers don't fall under the corrective action plan, but for the area agencies, they actually are able to provide both types of services. It just cannot be to the same person. So they could provide me with case management and Doreen with service coordination, but they couldn't provide me with both direct service and service coordination.
I repeat that it could be a lot clearer that that's the case, because it doesn't read that way, at least not to me. Representative Fellows?
Yes, I'm just wondering do other states use the same definitions, and do they use service coordinator and case management to describe the different roles, or is New Hampshire maybe different from other states?
I don't know specifically. I know that under the federal regulations for the waivers that we operate under, they actually make it clear in their guidance that the function of case management might be called service coordination or something else. So it's definitely permissible. I don't know specifically what other states do.
Any other comments, questions?
Madam Chair?
Senator Lang, yes.
So we have time on this rule. So I guess what I'd say is I think it's probably appropriate we postpone this and until next month, let them rewrite that section and make it a little more clear and cleaner, so that it's obvious that we don't have any of these conflicts that everyone's talking about.
Yes, because
So that's a motion.
particularly since we have been essentially caught with conflicts of interest and we're working on resolving them, I think it would be better if we're clearer, like you say, that the area agencies, don't provide case management and services to the same people.
So there's a motion to postpone.
Yes,
And I'll second.
Director Morrell?
If the committee is requesting the agency to modify the language, it has to be done either through a conditional approval or a preliminary objection. With a conditional approval, the language needs to be specific.
In that case, I think a preliminary objection would be in order.
So moved.
Okay,
That would be based on clarity.
yes, and public testimony. They pointed out okay. Any other questions? Comments? All right, those in favor of a preliminary objection?
Aye.
Opposed? All right, thank you. We'll see what we can do about that one. All right. Respiratory care practitioners.
Okay, yes, ma'am. This proposal would adopt regular rules that are currently interim rules, which are scheduled to expire on May 23rd, so next month. There are a couple of issues. One, the committee has actually heard about before, and that's on page 8 of the PDF document, and that's around the retention schedule issue. And like I said, we've discussed that before. My understanding is there's currently some legislation that would address that issue. So I wasn't going to spend a lot of time on that. The second issue is that there has been some testimony submitted, and you do have that at the tail end of your packet. And that testimony is on the fact that the rules do not address the licensing of student interns. But RSA 541A 22, Roman numeral 3, B does require specific authority to issue licenses. So an agency needs to have specific authority to be able to do that. And the respiratory care statute doesn't have any language whatsoever on interns or students, not their scope of practice, nothing on licensing requirements, just nothing. So, so it looks like there's some need for possibly for some legislation to address that issue. But again, there are some people here who have submitted cards and would like to testify on that. And with that, I don't have any additional comments.
Okay, thank you. Christy Baker? Oh, there we go. Yes, please.
Do you want me to address any of the comments, or would you like to hear
I'd like to hear the
testimony?
comments.
Got it.
Let's do the comments first, and
Okay.
then we'll take the public testimony.
Your comments.
Director. You're not turned on.
I turned it on, then I turned it off. I apologize. For the record, Lindsay Courtney, Executive Director, OPLC. With respect to the retention schedule issue, I think this issue has probably been discussed before. We did go through the Secretary of State's office, took about a year to get approval. What is posted on our website is the format that they sent back to me. I recognize that it may require additional clarity, but did not feel that it was within our purview to deviate from what was approved by the Secretary of State's office. Additionally, I do not believe that OPLC has rulemaking authority over retention schedules. Rather, our statute requires us to adopt a policy in accordance with the Secretary of State requirements. Secretary of State obviously needs to conduct rulemaking, and once that is done, we will be sure to follow those regulatory requirements. With respect to the student licensure issue, we have thoroughly reviewed this from a legal standpoint with multiple attorneys in the office. My understanding is that, and I'm sure you will, and I defer to others to explain the basis for it, I have no objection to the policy reasons why we may want to consider licensure of students. My understanding is that it's really from a reimbursement standpoint, but our position is that we do not have legal authority to do so. We considered maybe seeking legislation this past session, but given the climate of licensure changes, did not think that this was the right session to do so, and therefore happy to regroup with stakeholders and or legislators for next session if that is desirable. But from a policy standpoint, did not believe that this was the right opportunity to bring this up.
All right, thank you. Questions for the director? Seeing none, thank you. Okay, so are you together, sir? Ma'am? More or less. All right. Please introduce
hello.
yourself.
My name is Christy Baker Ebley, and I am a respiratory therapist within the state of New Hampshire. And
You have to speak into the
I'm sorry. I have a soft voice anyway. My name is Christy Baker Ebley, and I represent respiratory therapy. I am on the advisory board, a new member, so I'm not exactly good at how this whole process works. I had asked a couple of other members of respiratory therapy within our state. So I have, there's 3 of us here today to represent student licensure and a few other questions that we had. This is Patrick Von Kenoff.
Want me to start?
Sure.
Hi, so my name is Patrick Von Kennorf. I'm a respiratory therapist. Before we go into the student licensure section, I had a lot of questions regarding verbiage and wording of this, and it became clear to me that respiratory therapists weren't involved in the creation of these rules. So when I reached out to people from the advisory board who I know, I asked them if they were involved in vetting these rules, and they told me they were not. So I don't know if that is accurate or not, but there are a lot of questions regarding education requirements, what is able to be used for continuing education credits, When I reached out to OPLC to ask them for clarification, I specifically with a certain 1507.07a, asking if healthcare leadership classes could be considered for that rule. They told me it depends on if it's covered by the rule or not, was the answer I got. So I'm not sure if this has been fully vetted, and I guess that's why I'm asking you guys to postpone the approval here. As far as respiratory care licensure for
excuse me.
students. Okay, go ahead.
So, so you're concerned about the continuing education requirements?
Yeah, a lot of the they were vague to me as what was accepted. And what 1507.07a specifically, I asked if healthcare leadership classes would be able to be used for that, and the OPLC could not tell me if they would accept that or not.
Okay, it says they are either, all right. That does appear a little vague, who has to approve them, because any statewide professional organization sounds. Okay,
Then 1507.09a, there is other examinations that are very relevant to the profession of respiratory care. Higher level examinations such as the ECMO also has a E-AEC certification, which is extracorporeal membrane oxygenation certification, which is a higher end therapy that would be relevant here that is left off. So a bunch of questions about that, and that's when I got into the fact that the advisory board wasn't consulted in these rules.
okay, that's concerning.
As far as student licensures go, I guess one of the questions I have about student licensure is actually 1506.02 actually talks about student interns specifically. So I'm not sure, they're not licensed interns, but it comments on that.
1506.02. Internship allowed, okay. Okay, it specifically says that a person may work as an intern without a license if you're enrolled in a program to be educated that meets the requirements of the
So the vaguity there is, are we allowed to pay these interns? Are they allowed to perform independently, or are these actually just student internships where they are actually supervised? It's not clear.
That doesn't appear to deny independent practice.
Okay, that was not how I read it.
It says may engage in activity normally undertaken by a, that does appear to be a little vague.
Okay. And then as far as, so that's kind of what brought me into thinking that student licensure would be able to be approved by the RSA, and possibly it's not. But I just want to put a little bit of the scope of the problem of respiratory care. So while I know you've heard about healthcare shortages nationally, nursing programs are fully enrolled, right? They are filled. Radiology programs are filled. Currently, hospitals, or the larger hospitals that we represent, are about 30% down with our employment. Enrollment in RT programs is down 63% nationally, so that's 63% vacancies, including our local Claremont program. Of that, we are expected to grow 14% in the next 10 years. Of the students that are in the Claremont program, most of them are getting student jobs in Vermont because they're right on the border, and then when they're graduating, they're actually going to work in Vermont instead of New Hampshire hospitals because they've already built a relationship with their employers there.
And could you explain why they're working in Vermont rather than New Hampshire?
Because in Vermont, they're allowed to work as student respiratory therapists and get paid.
Yeah, okay, so they don't,
Vermont, actually Maine and Massachusetts all has student rules. We're the only one in New England that doesn't.
okay, and it is assumed that an internship means there's no pay.
That is my understanding.
Okay, thank you. I don't believe that's always the case, but if that's what people assume, that's.
Yeah,
what
I would love to hear otherwise.
Sorry.
Representative Hackett Phillips, yes.
So I'm guilty of being married to medicine. So yes, I think it's kind of an industry practice that if you're in an internship in a hospital or healthcare setting, that you are receiving compensation for that pay or that labor. So even if it is supervised learning, that there is a lot of work that goes into that. So
Okay.
I think proposing to train someone without paying them seems really unreasonable. So.
It's not competitive, that's for sure.
Right, well, we can't skip the statutory requirement that we have to have approval for that license, but,
So I guess my ask of the committee, and you can speak after I'm done, sorry, would be that you would postpone these roles and ask the OPLC to involve the Respiratory Care Advisory Board in reworking them and making sure that the vagaries have been made clear.
right, okay,
Madam Chair,
yes.
the interim rules expire on May 23rd. The committee is meeting on May 19th, so that's pretty tight. You could do a preliminary objection, but again, you know, the interim rules will expire on the 23rd
Well, if we're
of
meeting
May.
on the 19th,
Right.
I think that should allow us time to get a little clarity on your other questions about the education and training. The part about the student licenses, we can't solve immediately, so let's not worry about it for the time being. Even, if we can think of something that might allow it.
One, and as far as the clarification on the internship, if they're allowed to work, I guess the clarification I would be seeking is, are they allowed to work independently and are they allowed to be paid?
The independent part certainly could be clarified, and actually the pay too. I mean, I don't see why it should be mandatory that they're not paid.
Right, I think our historic assumption is that has been for students who come from education programs, and that is while they're with us doing their clinical time.
Okay, well, it sounds like a number of clarity issues that the board needs to be more involved in. Do we need to give a preliminary objection, or should we just postpone the decision?
You could postpone. One other issue I was going to just highlight is that in the definition of respiratory care in the statute, there is the concept of supervision of a less skilled person in respiratory care, but really that's the only place where you could kind of highlight there being a student or somebody not qualified to perform respiratory care, unlicensed.
Right. Just,
So,
Senator?
so I pulled up the exemption licensure statute. And it does say in there that it says related to a person's respiratory care education while under the direct supervision of a respiratory care practitioner or physician. So in the RSA itself, it defines that a person working under there, while they don't have to be licensed, they do have to be working under the direct supervision of a respiratory care practitioner or physician.
If I may, Madam Chair, I would like to address the notice issue. So these rules are largely based on the interim rules, which obviously went through a notice procedure, which were largely based on the prior rules. We did not receive a lot of feedback during the interim rulemaking, but we did receive feedback after the fact, and I do believe that these rules went through an advanced public comment period, meaning that we requested comments prior to initiating formal rulemaking. We did receive significant comments, particularly on the issue as it relates to equipment. Because previously, under the prior rules, one had to be licensed in order to basically manage and install equipment. So we responded to those comments, and you can see that at the end of our filing. I take issue with the representation that we did not seek stakeholder input. If you look at our website, all of the respiratory care meetings in 2022 were canceled. We are happy to work with stakeholders moving forward on these issues, including seeking a statutory change. But given that the interim rules are about to expire, I do not believe that it's in the best position for licensees that we postpone these rules. Rather, I'd like them to go forward, and then we can reinitiate rulemaking if necessary with additional stakeholder input.
So,
Yes.
so
Representative
can I just, am I understanding what you're basically saying is that although the people we heard from a moment ago are kind of complaining now, they had plenty of opportunity to have their input and they didn't take advantage of it then? Is that what you're saying?
Yes, and I think we can always do more communication, but the fact that we communicated is supported by the fact that people did provide comments that we responded to, as is listed in your packet as well.
Yes, thank you. Okay. Does someone have a motion?
Madam Chair, I'm going to move to approve, and I'd like to speak to my motion when I'm done.
All right, is there a second?
Second.
Okay.
So
Senator.
again, I think the combination on the student licensing, it's clear that there is no provision for OPLC to issue a license or they can't create a license out of thin air unless authorized by the legislature. So there's nothing they do to create a licensure that would allow an intern or a student to act. And the statute's clear that they have to act under the supervision. So I don't know that there's any necessary clarity that's needed there unless for some reason we want to license them. But as to the continuing education requirements and those conditions, again, I think the agency's been clear that they are more than willing to reopen rulemaking, that the interim rules are about to expire. We need to move forward so that the rule itself doesn't expire and the profession is injured or harmed.
Representative Schmidt. Actually, Representative Lynn can speak to a second first.
So, you know, I agree with everything that Senator Lang said. The only thing I would say is, while the statute that he read, I think does make it clear that a student needs to be operating under the direct supervision of a licensee. I'm not sure that there's anything in the law, unless there's another provision that hasn't been referred to, that would prevent a student from being paid. And so I think that's something that I'm not sure that would even need to necessarily be covered by a regulation. I think it's just up to the employer to decide whether they want to pay somebody. And it sounds like, given what the competitive situation, that it might make sense to start paying them.
Yeah.
But I don't know that we need a regulation for that. So anyway, I agree with Senator Lang's comments completely.
Representative Schmidt.
Thank you, and I agree with the previous speaker's statement. And would the senator consider amending his motion slightly to encourage further legislation, because it seems to me like the statute could be improved, but I agree with your characterization of what we have before us now.
Okay.
So
Senator?
again, I'm sure Mike made a list of legislative recommendations and changes, and I don't necessarily know what needs to be in the motion itself. But
Yeah. So I would think it would probably be better, I mean, if a person is a student but wants to be paid, they could be paid as some sort of medical technician and work under the direct supervision of a licensed practitioner, which I hope is the case. Because the intern is allowed to work without direct supervision. So I would think that if you're trying to get on the job experience for the sake of the profession, you would not want to just say, oh, here, you act like a respiratory therapist. Director?
Madam Chairman, based on personal belief, I think it's common that interns would be paid, but I think one factor in that may be the educational institution that the student is at. I understand it in some instances, if the intern is going to receive credit from the school may say you cannot be paid.
Okay, well, if that's the case, then that's up to the school to consider if that's affecting the,
But there is no prohibition in the rule itself from the individuals being paid.
okay. Yeah, I know ages ago when I worked as an intern, I got paid very well. But that was a long, long time ago.
So I just,
7
before we have a motion, I'm just,
We
have
have
a
a
question
motion
about
already.
the comment that the continuing education section was vague. Is that going to be addressed?
It sounded to me as though it was more incomplete. And Director Courtney, is there a way for the board to add additional courses for continuing education approval?
I think that the requirements are intended to be fairly broad so that more courses can meet the requirements. I think part of the issue we run into when people ask us questions like, would this qualify? Without having the course before us, we can't really say, conduct an analysis as to whether or not it would meet those regulatory requirements. And we're not really in a position to be giving legal advice in advance of reviewing that. Before it's submitted. So I think that our advice to boards is typically to keep it, fairly broad to capture all of the types of continuing education that you think could fulfill those obligations rather than creating discrete categories that would exclude things you might otherwise think is valuable education.
But you can approve
Yes.
non-specifically listed courses.
Yes, correct. Mhm.
Okay, good. That's
Yes.
the important thing.
Thank you.
And I'd like to mention to the therapists that these rules are normally written by lawyers and they do things differently than the rest of us. So if you have specific courses you want to get approved, sounds like that you should go ahead and ask for them to be included. Any other comments, questions? Okay, in that case, we have a motion to approve. Those in favor?
Aye. Aye.
Opposed? All right, thank you very much. All right, on to the Department of Safety.
So this is an interim rule, and for the newer committee members, that means that if it is approved, it will be valid only for 180 days to allow the agency to engage in the regular rulemaking process. This is a straight adoption of a new section, the 9100 section on the rules for carriage of household goods by motor vehicles. This is in result to a new statute, RSA 359T. That statute actually encompasses some of the prior requirements that were under RSA 375A, but 375A was repealed when this new statute went into effect. So a number of the comments on the interim rule can be addressed during the rulemaking process, but at this time, we want to bring it up now so that it can be addressed in the regular rulemaking process, or if the committee determines that they're too big of an issues that they need to be addressed before that. So the first issue is actually a note to jail car on the top of page 1 of the rule. So because there was a previous statute with similar requirement or similar language, the agency already had some rules in place under 4600 that they used most of the language for. Some of the rule requirements under 4600 are identical or very similar to what is now going to be 9100. But at this time, the 4600 rules, they're still in effect. So
would they have been repealed when the statute was repealed?
There, as far as I could see, there was no language in the statute, the repeal of the statute, or the new statute that resulted in those rules becoming non-effective. And because they have the authority now under 359T, which I said are pretty much similar, that would transfer to that statute. So there is a bit of a issue of which rules are going to be effective if the 9100s are approved today. You have two sets of rules that are effective at the same time. So perhaps the agency can discuss if they have plans to address that, or maybe come up with a plan to address that. The second substantive comment is on page 3 of the rule text. It's under the part titled Estimates. The rule specifically states that the carrier shall not charge the customer any amount which exceeds 10% without the customer's written consent. However, it's unclear from the rule's face what that 10% is based off of. It may be inferred that the agency intends it to be based on the estimate, but with regard to the standards for rulemaking, that's not clear enough. They should be stating what exactly that 10% is going to be based upon. The next comment is on page 4 of the rule text. That section regards voluntary suspensions. The rule text is not clear on what the department will consider when determining if they will allow a carrier to voluntarily suspend its certificate or permit, whether the agency is going to just automatically grant it as soon as they get the request, or if there's going to be criteria that they're going to be considering. Additionally, it's not clear when they will make this determination, especially if there's an ongoing adjudicatory process, because under these rules, the agency can also revoke a carrier's permit or certificate after the adjudicatory process has completed. So if a carrier puts in a request to voluntarily suspend after the hearing has already finished and the department is considering whether to revoke, how are they going to determine if they're revoking or voluntarily suspending? The next couple of comments have to do with the agency's forms. There are 3 forms that are that accompany this particular rule, and none of them are incorporated by reference. So a majority of the comments have to do with inconsistencies between the forms and the rule text. And I can go into the specific comments if the committee wants.
No, the inconsistencies between the form and the rule are the kind of thing I expect them to deal with in regular rulemaking.
Okay, so that would be the remainder of my comments.
Okay. Thank you.
Hi, good morning. Aaron Johnson, Administrative Rules Coordinator with the Department of Safety. For the first comment addressing the fact that we're going to have 2 different sets of rules in place, it's the department's understanding that it is unclear based off of the bill that had passed whether or not the 4600s are still in effect. So our goal is to put the 9100s into interim rules, and we've actually gained a lot of comments just from OLS over this, that we want to address in the 4600s, which we will continue doing that with regular rulemaking under the 4600s based off of the approval of the 9100s.
But it sounds like you're going backwards.
Yeah.
Isn't the 9100s the new rules?
They are the new rules for interim, and we intend to adopt the regular rules under the 4600s. We just wanted the interim rules in place while we figure out how to address the 4600s with the regular rulemaking.
Okay. Is anyone else confused?
So yeah, I guess to kind of clarify, we weren't sure whether or not the 4600s really did have any effect, and we're still working on drafting the language for the regular rulemaking. So we decided to do the interim rules under 9100 because if, let's say, we get these adopted and we have 6 months, if we don't adopt the regular rules within that 6-month period, then that would essentially wipe out the interim rules, and then the regular rules would disappear as well. And since we're unclear whether or not we still have authority under the 4600s, we want to reserve the right to be able to revert back in the instance that we don't have the regular rulemaking finalized.
So that's not the normal procedure. So you're putting these rules in as a 6-month temporary rule to cover the fact that you're going to be making changes in the other rules about carriers. Is that correct?
Correct.
Okay. If there is a conflict between the 2 sets of rules, which takes precedence?
The department's going to take the 9100s as precedent.
Then I would strongly recommend that you add that in case of conflict with the 4600 rules, these rules apply.
Okay, the department can do that.
That definitely needs to be added to the rule. Okay, anyone else? Representative Schmidt? You're still gasping? Director Morrow?
Look on his face.
I would suggest that in hindsight, the thing to do, if this was to implement new legislation, that the appropriate thing was to amend 4600 through an interim rule. I do understand that the question was about the validity of them, If the statute that 4600 implement has gone away, then I think there could be a presumption that 4600 is not enforceable anymore. I know it's a rather unusual instance here where there's a similar statute that's going to apply, but it seems like they should have just done 4600 again, or as they could, as part of the regular rulemaking, repeal 4600 and have everything in 9100.
That would make it clearer where the authority is. But I think our request is that you figure out what the permanent rule is, what the authority for it is, and make it clear to everybody, because you've got the whole room full of people confused. Senator?
So again, I'm assuming the agency is okay with adding to 9101 or 9100, that language at 9100 takes precedent over 4600 if there is a conflict, because we're still unsure whether 4600 is a valid, but if there is a conflict and it's determined it is valid, that 9100 is the precedent, not, or the standard, not 4600. Are you okay with that edit to the existing interim rule?
Yes, we are.
Okay. And I think the question about the 10%, again,
Yes, so that is going to be 10% of the original estimate that a household carrier would provide to the customer before signing a contract. So we'll just need to add that language in there to specify that it's of the original estimate, and that's something
well,
we
it's
can do.
actually, it's a be 110% of the original estimate.
Or, yes, 110% of the original estimate.
Okay. So,
Move to conditionally approve.
okay. Is there a second?
Second.
Any further comments, questions, discussion? Okay, not seeing any. Those in favor?
Aye.
Those opposed? No one. Thank you very much, and good luck with your rulemaking.
Yes, it's from all of us, I think.
Whichever rule it is.
Okay. Is there any other business?
No, Madam Chairman, we
No.
could determine to eliminate the continued meeting.
I believe that would make sense, yes. No continued meeting. In that case, unless there's an objection, we'll adjourn.
Language to say that